Hello, good morning. This video is on martial law. Article 34 provides for the restrictions on fundamental rights while martial law is enforced in any area within the territory of India. It empowers the parliament to indemnify any government servant or any other person for any act done by him in connection with the maintenance or restoration of order in any area where martial law was enforced. The parliament can also violate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under martial law. Indemnify means security or protection against financial liability, and forfeiture means loss by penalty for wrongdoing. The act of indemnity made by the parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. The concept of martial law has been borrowed in India from the English common law. However, the expression martial law has not been defined anywhere in the Constitution. Literally, it means military rule. It refers to the situation where civil administration is run by the military authorities according to their own rules and regulations framed outside the ordinary law. It thus implies the suspension of ordinary law and the government by military tribunals. It is different from the military law that is applicable to the armed forces. The martial law is imposed under the extraordinary circumstances like war, invasion, insurrection, rebellion, riot, or any violent resistance to law. During the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. They impose restrictions and regulations on the rights of civilians, can punish the civilians, and even condemn them to the death. The Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. The declaration for martial law under Article 34 is different from the declaration of national emergency under Article 352. Thank you.